What happens when a former president faces criminal charges? It's a question we've never had to ask before. Now, we are in uncharted territory as we watch the legal drama unfold around former President Donald Trump. Yes, you heard that right. A former president of the United States is facing criminal charges. This is not a drill, folks. The charges in question stem from a hush money payment scheme, a plot that sounds more like a crime thriller than real life. But reality is often stranger than fiction. The allegations are serious, marking the first time in the history of this nation that a former president has been arraigned on criminal charges. This is not just a footnote in history, but a significant chapter. Now, let's delve a little deeper into the charges. The Manhattan District Attorney's Office accuses Trump of falsifying business records related to hush money payments. For those of you not familiar with legal jargon, that's a fancy way of saying he's accused of lying about money used to keep someone quiet. But this is Donald Trump we're talking about. Never one to back down from a fight, he has responded to these charges with his characteristic bravado. He's been attacking the Manhattan District Attorney and the judge overseeing his case. It's been a spectacle, to say the least. Trump's argument, a witch hunt; his defense, attack. He's been firing off accusations like a Gatling gun, taking aim at the district attorney and the judge. It's a strategy that served him well in his business career and his presidency, but will it work in a court of law? Only time will tell. The court, for its part, has not imposed a gag order on Trump, despite his fiery rhetoric, but they have issued a stern warning against inciting violence. It's a delicate dance of maintaining the freedom of speech while ensuring the integrity of the legal process. The stage is set for a legal battle unlike any we've seen before. This is not just another courtroom drama, it's a historic, unprecedented case that will unfold under the watchful eyes of the world. It's a case that will test the very fabric of our democracy and the principle that no one, not even a former president, is above the law. Now, let's delve into the nitty-gritty of the legal proceedings. Picture this. We're in the year 2024, and the former president Donald Trump is in the hot seat. The timeline of the trial is a crucial element to unravel. There's a court hearing scheduled for December, with a potential trial set to commence in the early months of the following year. This marks a significant milestone, as it's the first time a former US president has faced such charges. The wheels of justice are turning, and it's a slow, meticulous process. Trump's attorneys have been given a deadline. They have until August to file their motions. This is essentially their opportunity to challenge the charges or argue for dismissal. Once they've played their hand, it's then up to the prosecutors. They'll have until September to respond, to counter-argue, to ensure their case is watertight. A protective order is also in the works. Prosecutors are negotiating this order, which aims to limit Trump's use of discovery materials. Discovery, in legal parlance, refers to the pre-trial phase where both parties can request evidence from each other. It's a crucial part of the process, and this protective order could potentially restrict the defense's access to certain evidence. Interestingly, Trump has been quick to resume his attacks on the Manhattan District Attorney and the judge overseeing his case. This has raised concerns about his rhetoric. However, the judge has not imposed a gag order on Trump, but has issued a stern warning against inciting violence. As these legal proceedings unfold, they're not just confined to the courtroom. They're playing out on a global stage. The world is watching, waiting, and wondering about the outcome of this unprecedented case. And as the saying goes, the wheels of justice turn slowly, but grind exceedingly fine. As the legal gears grind on, the world watches with bated breath. As if the criminal charges weren't enough, Trump also faces a sexual assault and defamation trial. Yes, you heard that right. In the midst of all this legal turmoil, the former president has another case to contend with. A case that dates back to the 90s. E. Jean Carroll, a well-known advice columnist, has come forward with allegations that Trump sexually assaulted her during that time. Now, this isn't a new revelation. Carroll's story has been in the public domain for a while, and it has been met with vehement denial from Trump. He dismissed the claims outright, leading to Carroll filing a defamation lawsuit against him. The basis of her lawsuit is that Trump's denial of her allegations damaged her reputation and career. But here's where things get interesting. With the criminal charges hanging over his head, Trump's lawyers have requested a delay in the sexual assault and defamation trial. Their reasoning? They believe that the intense media coverage surrounding the criminal charges could potentially bias jurors in the defamation case. However, Carroll is not on board with this delay. She is asserting that a fair jury could still be selected in New York City, despite the media storm surrounding Trump's other legal woes. It's clear from her stance that she is eager for her day in court, ready to face Trump and to have her allegations heard and examined in detail. So, where does this leave us? Well, we have a former president facing criminal charges, a sexual assault and defamation trial waiting in the wings, and a plaintiff who is not willing to let her case be overshadowed or delayed. It's a legal roller coaster that doesn't seem to be slowing down anytime soon. Even as one trial looms, another is on the horizon. The question is, will justice be served in both? We'll have to wait and see. In a twist of fate, Steve Bannon, once a staunch ally of Trump, has expressed willingness to testify before the House Select Committee investigating the January 6th insurrection. This development is a significant turn in the narrative, as Bannon had previously faced criminal contempt charges for defying a congressional subpoena. A subpoena is a legal document ordering someone to appear in court, and ignoring it is a grave matter. Bannon was not just a fly on the wall during the Trump administration, he was a key player, making his testimony potentially very insightful. His change of heart didn't come from out of the blue. It was a direct response to Trump waiving executive privilege, a decision that effectively gave Bannon the green light to testify. Executive privilege is a power held by the president to withhold information in the public interest. It's a significant tool in the presidential toolkit, but its waiver in this case reveals a shift in strategy from the Trump camp. The House Select Committee is eager to hear Bannon's testimony. Why, you might ask? They're particularly interested in his interactions with Trump leading up to the January 6th insurrection and the statements he made during that period. Bannon was, after all, in the thick of it all, and his account of events could shed light on the motivations and actions of those involved. But let's not jump the gun here. Federal prosecutors have emphasized that Bannon's late willingness to testify does not alter the case against him. He has yet to produce the subpoenaed records, and criminal contempt is designed to punish past non-compliance rather than secure future cooperation. So, the road ahead for Bannon, and by extension Trump, is still fraught with legal challenges. As the plot thickens, one can only wonder, will Bannon's testimony be a game-changer? Only time will tell. But one thing is certain, the ripple effects of this case will be felt far and wide, potentially reshaping the political landscape in ways we can only begin to imagine. As we stand on the precipice of these unprecedented trials, it's important to consider the broader implications. We are witnessing a moment in history where a former president is facing criminal charges. This is not just a trial of one man, but a trial of the concept of presidential immunity itself. In the United States, a sitting president has traditionally enjoyed a degree of immunity from prosecution for actions taken while in office. This has been seen as a necessity to allow the head of state to perform his duties without fear of legal repercussions. But what happens when a president steps down? Does this immunity still apply? These are the questions being asked as we watch these trials unfold. A guilty verdict would send a clear message that no one is above the law, not even a former president. It would set a precedent that could significantly impact future presidents and the way they conduct themselves both in and out of office. It could lead to more transparency and accountability, as presidents would be aware that they could face legal consequences for their actions. On the other hand, an acquittal could reinforce the notion of presidential immunity, potentially leading to a lack of accountability. It could create a precedent where presidents feel they can act with impunity, secure in the knowledge that they are unlikely to face criminal charges once they leave office. Beyond the legal implications, these trials could also have a profound impact on public perception. They are a reminder that even the highest office in the land is not immune from scrutiny. They could lead to a greater demand for transparency and accountability from our leaders, or they could further polarize an already divided nation. No matter the outcome, these trials have already made history and will continue to shape our understanding of presidential accountability.